Is it 20 minutes? Okay. Well, I'm going to be breezing through then a lot of my PowerPoint. I originally, hey, did you introduce yourself? Rudy? Are you an affiliate here? Oh, okay. Well, Rudy's going to be the next affiliate. He's a great guy. So, all right. So, I'm going to breeze through the PowerPoint because this typically takes about an hour to get through. I've already emailed the PowerPoint over. These are originally it was 5 most typical lawsuits I've seen in 2011, 2012. But it's expanded to about 9 or 10. So we're going to have to go through it fairly fast, or I'll skip through just some of the PowerPoints. Password on it is Paul Cheng Law, so you can open it up. It's essentially a summary of the goods and the bads that I've seen over the last year and what I think is going to be occurring in 2013. There are obviously, there's importance of today's lecture. When the economy goes bad, it's odd, but people do sue. And I think the reason behind that is when the economy is really good, there's a lot of money that floats, and because of that, people are just willing to let go of their problems. But when money is tight, people turn to attorneys because from a business perspective, if you spend $20,000 or $50,000 or $100,000 for $1 million, it actually makes economic sense. And so that's the reason why you see attorneys very busy during economic downturns. All right, so these are just the typical types of lawsuits. Is there a red, this one? Okay, so lawsuits are split up into 2 different groups, right? You have civil and you have criminal. I've combined criminal with quasi-criminal. Quasi-criminal basically means that it's a semi-criminal action. I used to be a city attorney, a prosecutor for the city of Hesperia, and much of what I did was just quasi-criminal area. Civil actions are split into contracts and torts. Contracts and torts. Torts are split up into 3 areas: intentional torts, negligence, and strict liability. Intentional tort requires an intention. If you don't have the intention to do it, you're not liable. Negligence are non-intentional torts. They don't care how you feel or how you think. Society creates a standard, and if you fall below the standard, you're liable. And strict liability. Strict liability, some of you have heard of like dog bites. It doesn't matter how you feel. If it happens, then you're liable. All right, so this is just a quick breakdown of lawsuits in general. Actually, it wasn't a very important PowerPoint, but anyway, okay. So, issue number 1 that I think is very important is who is responsible for a defect? Because I've seen a lot of lawsuits where someone purchases something and says, wait a minute, something happened to the home. I didn't know that the roof was going to collapse. I didn't know that there was a huge water leak. And therefore, as a plaintiff, I'm going to sue everybody, anybody. All right? Now, many of you, I think, wrongly believe your E&O is going to cover you. And you need to look at your E&O policies. And if there's an E&O insurance person here, you really should talk to them. And the reason why is, increasingly during an economic downturn, insurance companies are rejecting the claims. They're rejecting the claims because of the fact that the burden then is on the insured to try to get a claim in. And if you don't, then what ends up happening is the insurance company makes money. So it's very important for you to understand that E&O doesn't cover everything. And many times E&O, if you're sued for fraud, they absolutely don't cover it. All right, so. Failure to disclose. Denise comes into your office. She said that she is being sued by Peter. Denise represented the seller in a purchase and sale. The contract specifically said that she was not a dual agent. Denise is now being sued for failure to disclose. Denise obviously looks very masculine. I don't know what's going on. So Denise is now being sued for failure to disclose the fact that she knew that a ceiling on the property was weak. So she comes to you for advice. This is a very typical situation that occurs, right? Somebody represents another person and suddenly they're being sued. They don't know why. They weren't a dual agent, but they know they're being sued, so they come. The general misconception is most people that represent sellers do not believe that they have a duty to the buyer. They believe that any lawsuit that names them should be dismissed or found in their favor because they emphatically stated to the buyer that he or she didn't represent that buyer, right? You represented the seller. Why am I now being sued by the buyer? And the buyer is saying that there is a duty to me. Here's the breakdown of the law. In the past, it was called caveat emptor. I don't speak Latin very well, so it's buyer beware. And what that means is, whatever the seller does, it won't change the outcome of a fraud case. So if you buy it and the whole thing collapses, I'm sorry. That was before, all right? So the buyer's due diligence was crucial before. The breakdown of the law, the present day now, is different. It is now much more protective of buyers. Here is the scenario. If buyer had prior notice of the problem, then there is a presumption that you accept the problem. The seller or the seller's agent is not responsible. Actually, it's the selling agent, right? Okay, I always get that confused. Sorry about that. All right, next. Scenario 2. If a buyer had a prior notice of the problem and depended on the seller or the agent to make a decision, seller is sometimes responsible. Sometimes responsible. And the third scenario is if the buyer did not have prior notice and the seller knew about the problem and it impacts the value of the property, then the seller is responsible. So now there is a sliding scale in terms of liability, which is different from before. This, one of the important factors is latent versus patent defect. A latent defect is a hidden defect. A patent defect is obvious or not hidden defect. Now, the latent defect means that there's more potential seller liability on a latent defect. On a patent defect, there is more buyer responsibility. And the issue then becomes, did the person have notice? When the person purchased it, did they have notice of the defect? For example, you walk in, all right, so the purchaser walks into a home. They see a huge hole in the ceiling. It's huge, right? It's massive. They look up and they say, wow, that's pretty bad. Then they purchase the home and then they sell for a defect. Obviously, the seller is not going to be responsible, right? Why? Because of the fact that the buyer had prior notice. Now, what ends up happening if they walk in, there's a hole in the roof, and they basically ask the seller, what is it? And they say, oh, that's a sunroof, right? It's beautiful. It's a sun. Don't worry about it. Everything's okay. And the buyer, right, speaks to the seller and says, yes, oh, it sounds good. Then there's a sliding scale that goes back and forth. Unfortunately, in the law, many of the things are not concrete, and that's the reason why attorneys begin to litigate and fight over how much notice, what were the representations, etc. Unfortunately, that's where attorneys make money. We don't make money over black and white. If we did, it would be like doctors, right? You go in for surgery, you come out, if you feel better, you did a good job. Attorneys are totally different. Black and white cases, we don't like. Gray cases where everybody fights, that's where the attorneys make money. And unfortunately, in terms of defect cases, that's where the attorneys make the most money. All right. It's a sliding scale. The factors are how obvious was the defect, did the buyer know of the defect, and what did the seller do if the seller knew of the defect? Did the seller lie? Did the seller refuse to disclose? Lawsuits against brokers for non-disclosure. It's seller's broker is liable to a buyer of real property if the buyer fails to disclose material facts that are unknown to the buyer, intending to induce the buyer to purchase the property and resulting in damage to the buyer. Civil Code 1710, very frightening. Brokers have a general duty to deal fairly and honestly with all parties. It doesn't say only if you're a dual agent. It says all parties to any real estate transaction, including those not his principals. So this is very important. Extremely, extremely important for you to see that dual agent requirements, it doesn't lock you in. If you're a dual agent, suddenly you represent both sides. In my opinion, if you're selling property, you already represent both sides, whether or not you're a dual agent. This is what I normally see, right, with buyers, location, 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 brokers and agents, right? We tell them disclose, but the actual practice is close, 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 right? And this is where I think lawsuits occur, right? Right? You've probably heard that, right? Even in your own brokerage firm, right? Get it closed, okay? So Elements of this type of lawsuit, it's not a very important PowerPoint because I only have 5 minutes left, so. All right, let's see. Let me see another one that I think people have really looked at. Let me see. The as-is clause. Are you guys interested in that?
Yes.
Okay. All right. So David comes into your office with a lawsuit in hand. He said that Bob has sued him for failure to disclose. David thinks this lawsuit is frivolous because David specifically made it clear to all parties that the transaction was as is. David wants you to immediately tell Bob that David should be dropping the lawsuit. Your advice. As-is provision is not a get-out-of-jail-free card. A contract provision stating that no party or party representative has made representations, guarantees, or warranties of any kind or character does not relieve the broker or seller of liability for non-disclosure. Right? This is actual case law. So no matter, I know a lot of us have a tendency to write this in, right? This is an attorney that probably got sued later on for guaranteeing that his client was going to be protected. So this is the actual case that came out. And look how old it is, 1963. It has never been overturned. All right, very important. So, as-is provision, though, is a factor for whether the buyer was misled. All right, so I don't want you to feel that as-is has no purpose whatsoever. An as-is provision in a sales contract does not relieve the seller relieve the seller or his broker of liability for failure to disclose no material facts affecting value or desirability of the property. However, the as-is provision is a factor to be considered with all circumstances in determining if a buyer has been misled. So if you're using an as-is provision to hide a defect on the property, right, you will still be liable. If you are using the as-is provision, okay, I'll get to it. If you're using the as-is provision merely to just finish up the transaction, but you do it in good faith, that's going to be a better factor for you. Again, a sliding scale. Again, a sliding scale. All right, so that one's an easy one. It should be okay. You should understand it through the PowerPoint. I did want to go over order disputes, title insurance, commission lawsuits. You guys like that one? You should. All right. Let me tell you why. All right. Let me tell you why. Because I think a lot of people in this room have left money on the table. Let me tell you why. Peter comes into your office and says, that Sylvia wasn't fair. After signing an exclusive right to sell listing agreement, Sylvia turned around and sold the property, although Peter brought a ready buyer. Peter was told that he could not get a commission because Sylvia paid a commission to another person at the same office. What's your advice? Sound familiar, right? Right? Okay, so the listing agent has a right to the commission specified in the listing agreement if the listing agent, the owner, or any other real estate broker sells the real property during the time period of the listing agreement, or if the listing agent procures a ready, willing, and able buyer, even if the property is not sold. See, this is a very important concept. For those of you that have brought the buyer and they are ready, willing, and able, then you have fulfilled the terms of the contract. So for those of you, when the transaction has fallen through, you really should be asking yourself, have you left money on the table? For action for commission on exclusive agency, see this case. So I've already written the case and you can read it. All right? I think it's very important. Sale or procurement of a ready, willing, and able buyer. Sale, there is a legally binding commitment to sell, lease, or exchange the property. Listing agent is entitled to his commission even if he was not the procuring cause of the sale, and even if he could not perform by tendering a satisfactory buyer. What does that mean? That essentially means that even if the transaction didn't go through and it went through somebody else, if you had the ready, willing, and able buyer, you are still entitled to the commission, and the person essentially would have to pay a commission twice. Right? It's very, very important. It's very important. So, a full commission is due if the owner sells the property, even if the listing agent has made no effort nor incurred no expense in marketing the property. This is case law that's come out. It's pretty frightening, right? Why? Because you have a contract with the seller. You have a contract with the seller. The seller then goes around your back, sells it through somebody else. There is case law out there that says even if there's been no effort, what they typically do is they complain about you. They say, you're terrible, you're horrible, I shouldn't have gone through you, you didn't do anything, I didn't see anything. I mean, that happens, right? Because essentially they don't want to pay a commission to you. Case law has said it doesn't matter. As long as you have the contract, you must abide by the terms of the contract. Okay, two things. One that I don't think is on here, that I've spoken of quite a bit, is the Business and Professions Code 143 and 7031. I think it's important because we have people in here that have licensing issues. If you are unlicensed in the state of California and you are required to be licensed in the state of California under Business and Professions Code 143, you cannot sue for any type of compensation whatsoever. That includes real estate brokers and agents, that includes attorneys, that includes people in the foot massage parlor industry that are required to be licensed, that includes cosmetology, etc. Why is that important? Because I would say about 20% of the lawsuits that come into my office, the defendants say to me, you know, I'm so sorry, I used somebody to build on my house, and you know, there was a dispute, I didn't pay them, and now they're coming after me. And they were unlicensed, I'm sorry, I was trying to do things on the cheap. I say that's the greatest type of lawsuit that you can be able to have, because under Business and Professions Code 143, you don't have to pay. They can build you a house, a $5 million house in Arcadia, and you wouldn't have to pay them a dime. Under Business and Professions Code 7031, in the construction industry, it goes one step further. Any monies that you've paid to them already, you can sue them and get the money back. So let's say that they built a $5 million property for you. You've paid $1 million. Then they decide to sue you. You would say, Business and Professions Code 143, I don't owe you the balance of the $4 million. And under Business and Professions Code 7031, you must pay me back the $1 million I already paid you because you are an unlicensed contractor. Okay? Now, I am going to end with this. It's very interesting. Just a couple days ago, 20% to 30% of my cases, we're blessed in the sense we have a lot of cases. So what I do is we try to take on cases that effectuate change within the community. So we actually sued a sushi restaurant. The sushi restaurant was making their workers essentially work as slave laborers. And many of the buffets, they're very inexpensive. We sue them because they don't get paid. They only make money off of tips. And it's an unfortunate kind of thing that goes on with an industry in general, which is the restaurant industry in general. And when she called and we said we settled, she broke down and she cried. She said, I'm so happy. My daughter, she's going to college and I don't have any money. I actually can't pay for her. She was going to leave college and she was going to work. And this helps me at least put her through college. Now, the reason why I'm sharing this with you is because of the fact that November is a pretty big election time. And the thing that I'm concerned about, particularly in this San Gabriel Valley area, is I'm slowly starting to see a division. We are all Americans the day that we step off the plane. I don't care if you're a US citizen or you're not. And we must comply with the law, and we must all do our fair share. It's interesting. I think there's a purpose why the West San Gabriel Valley, the association, is right on Valley Boulevard. If you actually have known people in San Gabriel, people north of San Gabriel say, oh, I don't go down to the valley. And you say, well, what does that mean? Right? You don't go up to the 101, 405. They say, no. I don't go down to the valley, meaning they don't come down south of Valley Boulevard. In Arcadia, we have the same problem. There are many people north of the 210. They won't drive on Baldwin Boulevard because they can't read any of the signs. I can't read any of the signs, although I speak Mandarin. Now, why is that important to share with you, right? I'm up here, and I think I have the opportunity to say that we all got to come together as Americans. And real estate and real property and homes is one of the things that can bring communities together. And so I really want to encourage you to really think about that. Because unlike lawyers, where our job seems to divide and tear and rip the other side to shreds, and the more you do it, the happier your client is. For you, when someone goes in, it doesn't matter what nationality they are. You could be completely blowing open the doors of an individual, particularly an immigrant that comes to America. And I just wanted to remind you guys of that and say you guys are doing an awesome job. For those of you that are discouraged, you may feel like life is just there's no purpose. I want you to know you do have purpose. Every person that you talk to and you touch, because they need you. They don't necessarily need me. They just have no choice because they have this court system that they can't figure out. But they need you and they want you. And every time you communicate with people of any nationality, I want you to know you're being a good American, because at the end of the day, home ownership is one of the foundations of America. And I wanted to thank you for allowing my family to come here, because without a realtor, we would not have been able to come to the United States. So thank you very much for your time.